Hi everyone, my name is Lena Nguyen. I'm a family law attorney licensed in Texas and California. Today I'm going to talk about how to prove that an asset is your own separate property. 9 states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin are considered community property states. That means that all assets that is purchased or acquired by a couple during their marriage is considered jointly earned and is subject to division upon divorce. Gifts and inheritances are an exception to this law. So if you're specifically given a gift or you inherited a property, it is your separate property regardless of whether you were married at the time. How do you prove an asset is separate property and not community property? Well, Texas and some community property states follow what is known as the inception of title rule. California does not follow this rule. To establish a property as separate property under the inception of title rule, you must follow these 3 steps. Number 1, determine the date you first acquired an ownership interest in the property. This is also referred to as the inception of title date. When did you first acquire rights to the property? It is not the date that you got complete ownership and control of the property, but rather when did you first gain an interest in the asset. For example, in the purchase of real properties such as a home, the inception of title date would be the date that you signed the earnest money contract. It does not matter that on the date you signed the contract, you neither had possession of the real property, which is your home, nor did you have legal title to the home. Inception of title is related to the beginning of ownership of an asset. Number 2, what was your marital status at the inception of title date? If you were single, the property will be considered separate property. If you were married and the property was neither a gift nor inheritance, it will be considered community property. In Texas, if you were separated, the property will be considered community property, if it was neither a gift nor inheritance, of course, because separation is not considered a legal marital status in Texas. In other words, separation dates do not matter in Texas. Number 3, how was the property acquired? If the property was either a gift or an inheritance, it is considered separate property. If the property is a recovery from a personal injury claim, it is considered separate property. The parties can also come to an agreement as to what they would consider separate property. There are 2 types of agreements that fall under this rule. 1 is the partition and exchange agreements, and number 2 is the right of survivorship agreements. Partition and exchange agreements are created when spouses agree certain property that is already acquired or that they will acquire will remain separate property. Right of survivorship agreements are created when the spouses agree that all the property that's listed in the agreement will become the separate property of the surviving spouse after the other spouse dies. Additionally, courts presume that property purchased with cash during the marriage was purchased with community cash and thus will be considered community property. To refute this, the spouse has to put forth evidence that the property was purchased with his or her own separate funds. Likewise, the courts also presume that property purchased with credit during the marriage was purchased with community credit and thus considered community property. In order to refute this presumption, the spouse also has to put forth evidence that the property was purchased with his or her own separate credit.
Thank you so much for watching. Please give this video a thumbs up and subscribe to my channel. Also, if you live in Texas and would like a free self-help divorce kit, please check the description box below to sign up.